We begin with a story out of New York City, where various teachers refused the shot and were fired and are now being hired back with back pay because the illegal discrimination. So yeah, we've seen this story before, not for the first time. Not everyone has gotten this outcome, but we've certainly seen a few of these stories where people were forced to take the shot and said no, and in some cases were fired. And of course, in some cases, they took action against their employer, whether that was a school district or the military or whatever. And we've occasionally seen where these people have won their lawsuits and gotten some sort of damages for the illegal. In this case, they get their job back and also get paid for all the time that they should have been working, but weren't working because they were illegally fired. So it does occasionally happen. Let's learn a little bit more about this illegal shot mandate in New York City. Let's get started with this. A New York judge said on Wednesday that 10 employees who had been fired by the New York City Department for Education for refusing the shot must be reinstated with the back pay. How about you give them all the money and any other sort of benefits they would have accrued during that time? So, you get the money, and like money for the health insurance and any sort of credit towards your retirement or pension or whatever else. Basically, put you back in the same position you should have been this entire time because what they did against you was illegal. In a major victory for the vaccine mandate opponents, the state trial judge named Ralph Porzoro held the city's denial of religious accommodation to be the problem. So the problem was that these people said that they had a religious discrimination issue. Discrimination on the basis of religion. We don't want to do this because we have a religious problem with it. And religion is a protected class. So, can you fire someone for not taking the shot? Maybe. Can you do it specifically if they're not doing it because of religious reasons? Well, as always, that presents some interesting complications because freedom of religion. So they said, we have a religious-based problem. And the judge said over here, the problem was in processing these denials, you were arbitrary and capricious. Basically, you were just making stuff up, which you're not allowed to do, right? Maybe you can treat the religion the same as the non-religion. There are many cases that speak to that generalized proposition. My personal favorite to cite is a case called Smith, that stands for that proposition, but you could cite other cases. Not the first time the Supreme Court has said it, right? So maybe you could treat the religion the same as the non-religion, but if you have a process for religious exemptions, you can't just deny them because you feel like it, right? The government can never act arbitrarily and capriciously. That's something the government can never do. If it's just throwing darts at a board, that's illegal. So the trial judge says, okay, you were just throwing darts at a board in saying who gets a denial and who doesn't, which is illegal. The case concerned school principals, teachers, and other educators who sued the city officials after they rejected their claim for a religious exemption. The court writing, it sees no rational basis for not allowing unvaccinated classroom teachers in amongst an admittedly a population of primarily unvaccinated students. So that is a problem, right? Rational basis is sort of your bare bone minimum for the government to do anything when you're thinking about tiers of review, tiers of scrutiny. So the judge kind of slapping you down says this isn't strict scrutiny. This isn't a problem with religion. This isn't even intermediate scrutiny because you're treating the religion the same. This is rational basis review. And you've managed to fail that, which occasionally does happen and is always hilarious because it's really hard for the government to fail rational basis review. Any reason will be fine, but it has to be a rational one. It has to make sense on any level. And the judge says, okay, what you said is one of the stupidest things I've ever heard, and we're all stupider for having heard it in so many words. It fails the bare minimum rational basis review because all the students at this time are unvaccinated. So why you say the teachers have to be vaccinated, but the students don't, right? It doesn't make any logical sense, says the court thinking. And it's like, the logic part of my brain hurts, says the court. So this is some BS. The judge continuing to write, as the decision summarily denied classroom teachers among the petitioners basis of exemptions on undue hardship, namely religion, without any further evidence of individualized analysis. In other words, we didn't look at their particular cases. We didn't look at their particular reasons. We just said no. That would be the arbitrary, capricious, and unreasonable. So they said we have an undue hardship, namely it offends our religion. And apparently the school did absolutely no investigation or no inquiry or no individualized analysis whatsoever. They just said deny, deny, deny. We're going to deny them all. Yeah, you can't do that. You can't do that. You actually have to, look at it and approach it in a rational way. You can't make the decision in advance and then just get out your rubber stamp deny. That is not something you can do. The judge continuing to write that as a result of all this, they would have been entitled to a religious exemption from the vaccine mandate because, the government didn't rebut it, which maybe they could have, but they didn't even try. They just said no, which is not the same thing. New York's vaccine mandate for all Department of Education workers was in effect from October the 1st, 2021 through February the 10th of 2023. Thousands of teachers and other education workers lost their job under the policies for refusing to comply with the mandate. So they fired a whole bunch of people, but some of these people they fired despite the fact they claimed religious exemptions without any sort of effort to figure out if it was a bona fide claim or if perhaps the mandate should go forward despite the exemption. Maybe it's so important that, maybe we shouldn't ignore the exemption. But they didn't even think about it. They just got out their red ink and no. One of the lead attorneys for the plaintiff celebrated the victory as a watershed moment for the teachers in their 2-year fight for relief, according to the news release from the Children's Health Defense, which is a nonprofit that has been funded at least in part by Robert F. Kennedy Jr. So Robert F. Kennedy Jr. entering the mix just to make things extra special, interesting, which, okay, I mean, you can be a vaccine skeptic or not. One would imagine you should have the choice, right? I mean, you should have the freedom to make the decision for yourself, right? My body, my choice. I seem to remember hearing that somewhere. And these people over here like, I have religious exemptions on top of it. And like, 9, you will comply with our mandates. But it's not fascism, right? It's totally cool. The judge doesn't really see it that way. According to the attorneys fighting for this thing, the court's decision not only grants relief to these teachers, but also sets an important precedent for all their teachers denied religious accommodation. The ruling by the trial level court in favor of the fired educators does not extend to petitioners who had not applied for religious accommodation. So this is all based on them processing or not the religious accommodation, right? So we have given a process by which to apply for an exemption on the basis of religion. Not necessarily clear we had to do that, incidentally, right? Maybe we didn't have to do that in the first instance because maybe we could have treated the religion the same as the non-religion. So maybe the fact you have a religious reason isn't good enough, but we did give you a process for religious exemptions. We did say you could apply for religious exemptions. Okay, well, having given us that opportunity to do that, you then actually have to process those things. You can't give the opportunity and then just be like, nah, fam, we're not going to grant any of them. If you feel that way, don't offer the exemptions at all. But if you do, you can't deny them arbitrarily and capriciously. That's something the government cannot do. The court agreed the employees were not required to submit applications through the prior unlawful process, but still declined to award relief to plaintiffs on the grounds that there were contested issues of fact as to whether they submitted applications under the new process. So partly there's an issue of fact for some of the people in issue. So the court unable to rule as a matter of law because there's a dispute of fact as to whether or not some of them applied for the exemptions. The process may have been broken. It may have been illusory, but you still have to do it, right? Because then when the government denies you the illusory process, you can say, aha, the process was illusory. But if you never give the government the chance at all, even though the fix was in, the government can say, well, we would have granted them had you just asked. So even though it's a little BS sometimes, you have to undergo the process, even though the fix is in, because then you can say, well, the fix is in, the proof is there because they did it, as opposed to the speculation. So there's a dispute of fact as to whether or not some of the people applied for the exemptions or not. So some of those people will have to prove whether or not they applied for the exemptions or not before relief can be issued as to them. The court also rejected a motion for class certification, stating the proposed class was overbroad. So that's one of the issues when you're dealing with a class of any kind. You have to make sure that the class is sufficiently defined so that they're all, within the bounds of something that makes sense. The court here is saying, well, I'll grant relief for you, but I won't give you your class certification because the way you've defined your class is not well constructed. So you get relief. At least some of you guys get relief. Some of you guys have to go back and prove it. And for the rest of them, well, the class is not sufficiently defined. So other people who didn't sue don't get relief as a result of this lawsuit. But of course, they might get relief as a result of some other lawsuit, or of course, they could have brought their own as they might see fit. The attorneys writing for the winners say the judge's ruling, while not everything we wanted, is a precedent-setting victory, which I will take note that strictly speaking, it's not precedent-setting because it's a trial-level decision, but we'll forgive the slight use of language. The court's ruling in the class certification still leaves open future relief for thousands of teachers negatively affected. Possibly, you might be able to rewrite your class, depending on what the judge said, so maybe you give that another go. We therefore intend to file a motion for reconsideration on a narrower basis. Rather than wasting public resources clogging the courts with individual lawsuits, legal action that will remedy these policies for all only makes sense. So yeah, maybe they might be able to give that class another shot, depending on the judge's decision. So I don't like this class construction, but depending on what the judge wrote, maybe a different class construction. So we may yet be able to do this in a more global way. One of the teachers who was fired as a result of these illegal practices by New York City has said, quote, "Today's ruling is bittersweet. While it's an important step in the right direction, justice for only 10 of us doesn't even scratch the surface of the injustice suffered by the New York City workers as a result of the illegal mandate," which, to be fair, sure, but at least it's released for the 10. And it's a start. And it's a guide for other attorneys and other cases. And it's a guide also on how to figure out your class action stuff. So everything, even negative results, is a learning experience. So they will press forward with a revised cause of action and perhaps bring relief to other people who were affected who didn't bring their own lawsuits. Thus, that brings us to the end of discussion for the moment about the New York City teachers who have won their lawsuit as a result of the illegal discrimination on the basis of religion, and also the fact that it failed even rational basis review. So this only impacts 10 teachers and principals and school officials, but it's a start, and also potentially gives a guide for future action in New York City and of course beyond as they try to figure out the representative classes. So the problem here, at least in part, seems to be that New York City, although it said we'll grant you religious exemptions, didn't actually do that, and they did so in a way that was arbitrary and capricious. So they basically just threw darts at a board, which you can't do. So these 10 people win their lawsuit, they get their jobs back, they get the back pay and relief for the rest. We'll have to proceed through the courts as it does. And at least for the moment, that brings us to the end of discussion of this case.